Mukul Rohatgi, one of the sharpest legal minds in the country. Sir, thanks very much for speaking to us. My first question to you, here's a situation where there is a single largest party with 108 MLAs. The effective strength is 107. The halfway mark is 117. 118 is an absolute majority. Before the governor is there with no one else taking claim to form the government, the question is, should Vijay have been allowed to be sworn in and then prove his majority on the floor of the House? Or is the governor well within his ambit to say, I need to be convinced that you have the numbers before I swear you in?
I think the governor's action is unconstitutional. Mr. Vijay's party is ahead of the pack by leaps and bounds, and he is within touching distance of a majority. The law is that majority has to be proved on the floor of the House. It has not to be proved before the floor of the governor or the Raj Bhavan. That is the mistake which the governor is doing. If Mr. Vijay is so close to the magic number, he should ask Mr. Vijay, you take over and prove your majority in 4 or 5 days. In that time, he can get a letter of support from X or Y and form the government, number one. Number two, it is not unknown that even minority governments also function. We have an example of Narasimha Rao's government. So he should allow Mr. Vijay to come forward. It is a great verdict for a newcomer who has dismantled the Dravidian parties who have been there for, more than half a century. The verdict and mandate of the people must be respected. There is no way that Mr. Vijay should be asked to wait. And wait for what now? The state will be without a government. How long should this continue? This is not correct at all. So Mr. Vijay should be asked immediately to take over and then prove his majority.
Important point that you're making it categorically clear that it's unconstitutional and he should be allowed to be sworn in and prove his majority not before the governor but on the floor of the House. But may I ask you this question? A counter argument that's been given is that Vijay did not approach the governor as a single largest party. He approached the governor with the Congress as a coalition, and hence the governor has demanded that, look, if you're approaching me as a coalition, give me 118. At least demonstrate to me that you will have 118, because there have been multiple different precedents and the governor is also supposed to prevent a situation where there will be horse raiding.
I think this is a completely wrong argument. If he could have gone with 112 and he has gone with 117, I think his case becomes better, no? How can it become worse? I don't understand that. If it is already +5, he is very much there.
No, sir.
Even if you ignore the
argument
Congress
that's been put forth, and obviously,
sir, please understand, even if you ignore the Congress, he's the single largest party by leaps and bounds. So give him an opportunity. The fact that he has got Congress along with him is only something to bolster his stand. It is not to dilute his stand.
It's an important point that you're making. Can you give us clear precedents to this, sir, where it has to be, it's incumbent upon the governor to ensure that there is at least aid and help, that there is a formation of a government, given that there is a single largest party by a mile, and the optics and the perception is categorical that Vijay has won the mandate of the people?
Is there a doubt about the mandate that he has won? It's a stupendous mandate. In a scenario where 60-year-old parties have been thrown to the winds, the chief minister himself has lost. And I gave you the example of Narasimha Rao's government at the center, which functioned as a minority government for a number of years. So please allow somebody to stake his claim. It is not as if he has got 112 people who are imposters or impersonators. They are not imposters. They have won the mandate of the people. He's got a full list ready. We have seen cases where some people have said our signatures are forged in that list. This is not one of those cases. It's a simple, clean case. I do not think it admits of any doubt whatsoever. Thank you.
Important point again that you're making, sir, is again the larger issue that comes up is the one of discretion of the governor, the discretionary powers of the governor. Is it time perhaps, sir, again to codify and ensure that it's not left to some arbitrary decision, but one that is categorical in cases of this nature?
Now, look, it is very difficult to codify everything, but there are some constitutional rules. There are some constitutional, aspects which are taken care of. This is how it has gone. It has gone on in a number of years, and as I told you, the law is that it is a floor test, which is important, not a test on the floor of the Raj Bhavan. Please understand that. And the discretion of the governor, is a constitutional discretion. It is not somebody's own fiat that I like you or I don't like you. That can't be done. It is a constitutional discretion to be exercised in accordance with the ethos of the Constitution. And the ethos of the Constitution says majority must be allowed to stake the government, mandate of the people must be respected, and the only way whether he will win or lose is the confidence of the House, and that is the bottom line, sir. Thank you.
Very quickly, one last question before I let you go, sir. We believe that the TVK is also exploring legal options. Do you believe that this could again be another case that goes to the courts? How do you see the courts viewing this situation?
Well, I'm not too sure whether TVK should just rush to the court. It might delay it. Maybe better sense will prevail with the governor and he may call him in the next 1 or 2 days. But if he does go to court, the court can direct the governor to ensure a flow test. I remember a case I did many years ago or several years ago in regard to the Karnataka Assembly, where the governor was dilly-dallying and not doing a flow test, where BJP, I think, was wanting to have a flow test. And we went to the court, and the court said that the governor should not dilly-dally and take a call and do it. So that kind of thing can happen, but I don't think it is necessary in the facts of such a case. I think the governor would be well advised to do so.
You're again making a very nuanced, important point that going to the courts could only delay that. It's incumbent upon the governor to call him, to swear him in and allow him. Would you also allow him to prove his majority on the floor of the House? Would you also believe that the time limit is discretion of the governor, how long he gets to prove his majority? Would you believe that that also needs to be categorically defined? Or do you believe that that can also be left to the discretion?
No. Precedents of the past have shown that the governor can, grant time of 3 days, 5 days, 7 days. It can't be 1 month. Because that long time was, an unusually long period of time was seen as a handle for horse trading, where you are nowhere near the winning post. You see, it is that kind of a situation, but this is not a situation where you will do horse trading. You are virtually there at the finishing line. You have just to get 5 or 10 more and that's it. So it should be 3 to 5 to 7 days and that's all.
All right.
Thank you.